Hello, I'm Anthony Zoller, and welcome to the Employment Law Report. For the next couple of videos, we're going to be covering some fundamentals about how to conduct terminations in California. So on this first video about how to conduct terminations in California, I want to talk briefly about the reason the employer provides to the employee at the termination and how to document that, and then just a basic overview of when final wages are owed to terminated employees or employees that are leaving the company. So starting out with terminations in general, it's so important to document the reason for the termination and to be truthful in documenting the termination. And it's so easy for employers to fall back to the easy route and tell employees that they're just being laid off and not have the difficult conversation with the employee that they're being terminated for poor performance or conduct or for cause. So it's important that employers step back and really be truthful and document the true reason, because it's one of the most probably evaluated and critical decisions that the employer is going to be making. A decision to hire somebody is not going to be challenged in the court of law, and most other decisions aren't going to be as closely scrutinized as the decision to terminate. And that's why employers really need to be careful about what they tell employees for the reason for the termination, and then documenting the true reason. So if you have for cause to terminate employee or cause to terminate employee, you really need to communicate that to the employee and document that. And I know it's hard to have that conversation, but it's so critical. If the employee turns around and files a lawsuit against the employer, that the employer does not change the story then and say, well, tell the employee there was a layoff when they did the termination, but then when the employee sues, the reason now is for poor performance. It's not going to look good, and the employer loses credibility. So it's important to keep that in mind when documenting the termination. But when you're telling the employee, you just need to do it with respect, and you can do that and still communicate the true reason. And it's so important to have the employee feel like they've been respected through the process. And if you're upfront with the employee about the true reason for the termination, they'll understand it and they know what's going on. Now, quickly, I just wanted to talk briefly about final wages and when those must be paid. So if an employee is terminated, all final wages, including any accrued and unpaid vacation time, needs to be paid out at the time of termination. And this goes for employers that are even located, their headquarters are out of state. If the termination occurs for a California employee here in California, all final wages need to be paid at the time of termination. And I know that's a hard obligation to meet sometimes for out-of-state employers when the checks are cut from in different states and then mailed to California, but it's a requirement that needs to be met for all California employers. Now, if the employee gives notice that they're quitting, it's the rule of 72 is what I call it. Basically, if the employee gives notice of more than 72 hours that they're resigning, then the employer needs to provide the final wages at the last day, if the employee gives more than 72 hours notice. Now, if the employee resigns without giving more than 72 hours notice, then the employer has 72 hours after the employee resigns to provide the final paycheck to the employee. So it's really critical to keep that in mind. Some other issues to keep in mind about final wages. One is, should you mail final wages to an employee or not? You need to be careful about that, because if the employee shows up at the place of business asking for their final wages after a termination or they've resigned and you don't have the check because it's in the mail, the employee may be entitled to additional waiting time penalties. So normally have the employee give it to the employee in person, or tell them it's available to pick up at the office. Also, to keep in mind as well, the final bonuses and commissions. Employers do have some additional leeway of when to calculate. If those are hard to calculate or it takes time to calculate those, the employer does not have to provide and do a calculation on that. If it can't be done at the time of termination or resignation, they do have more time to provide those to do those calculations and provide bonuses and commissions at a later date. But I do recommend employers act on those quickly as possible and make those payments. And the same thing goes for expense reimbursements as well. If the employee or the employer may do the expense reimbursement at the normal time that expenses are normally reimbursed to the employee, even if they have left employment. And then I want to leave the final point on final wages is direct deposit. Unless the employer has a specific authorization from the employee to directly deposit the final wages, any other direct deposit authorizations do not comply or are not valid when it comes to the final wages. There has to be a very specific authorization from the employee about their final wages that those may be provided by direct deposit. So it's something to keep in mind. So with that, if you want any additional information, feel free to reach out and email me. Please subscribe to the channel. And also, if you would like a checklist that I put together, a general checklist for California employers about termination steps that every employer should review, please feel free to email me and provide your information, and I can send you the checklist to review. Thanks for watching.